Okay. Ooh. Okay. Okay. Where are you? Didn't hear me. Sorry. She. How long I got cut off?
I think the last one you said was when it was something that we should be able to have access.
Okay, so I went on to say that even in casual conversation, so you may just be having a conversation and you would say just say for instance you're having a conversation with another friend in a social setting, and I may happen to pass you and you just say hello, Mr. Ossett. And the person who you're having a conversation may say, well, where do you know her from? And you then say, well, that's my customer. She have some accounts with us. She don't even pay good, but anyway, you think that's something that you should have a conversation with? You should have a conversation about that is prejudicial to your client, and that's not for you to discuss. I know in private banking in particular, when I worked in private bank with the Swiss banks, we were not even allowed to acknowledge our customers outside of the bank, because the mere fact that you acknowledge them means you know them, and why would you know these people other than in that setting? Because otherwise it won't seem as if you all are socially, you all come together socially. So it was discouraged that you even acknowledge them outside of the bank, because then somebody could start to associate. Well, okay, so them from here. That means this guy could start to look where they may have an account, you see?
Mhm.
So it was always that you have to keep the distance there. So you don't want to prejudice your customer's financial position with anyone. So that's why if they need credit references, they have to ask you for a letter to disclose that information to another bank. It's not that the other bank should be able to call you up and ask you about your customer. That should never be the case. And no matter what the relationship is you have with the other banker, it should never be, because I mean, you could be found in breach of your duties. Notwithstanding, the bank may have some course of action. They'll have some course of action against the bank. They also could have course of action. The bank may have some course of action against you. Okay. Now,
Mr. Asad?
Okay, I had to move. Look like that connection where I was kept dropping. Sorry about that.
Okay.
Okay, I was asking you all if you remember what R.V. Grossman referred to. What we said about R.V. Grossman. You remember? Where the branches of the same bank, remember that? In several jurisdictions with different entities. No? I'm still on or no? Y'all can hear me?
We can
You're
hear
still
you.
on, Ms. Dawson.
Oh,
I
gee.
don't, hello?
Okay, I just was wondering. Remember, that's the case where Gonzalo Cebola said that whilst they are one bank, they're different entities and they have branches in different jurisdictions, so they subject to the laws of that jurisdiction.
Yes, I
Yes,
remember that.
ma'am.
Remember that?
Yes, ma'am.
Yeah.
Okay, what case we gonna look at for the exceptions to the duty of confidentiality? It should be right in your mind. We just talk about that case.
You're talking about the 20th?
Yeah, attorney is the case.
Versus national.
Yeah. They give us the 4 exceptions. What are the 4 exceptions?
A compulsion of law
Mhm,
in the public interest,
mhm,
the trustee's interest,
mhm.
and with the express or implied consent of the party to a trust,
Okay,
specifically the beneficiaries.
excellent. What type of duty does the banker have of confidentiality?
Is it a fiduciary duty?
Fiduciary duty. It's a fiduciary duty. And what is it governed by? What kind of law is it governed by?
Common law,
And
statutory.
Statutory law.
what is the statutory law? Where I'll find that statutory law that deals with confidentiality.
The only thing coming to me at the moment is section 83 of the Trustee Act, and I know that's not it because
That's right to
for the
information.
beneficiaries. Yeah,
Right up. Section 19(1) of the Bank and Trust Companies Regulation Act, remember that?
okay. Yes, ma'am. Now that you
Right.
said it, I remember.
Yes, so it deals with confidentiality in the Bahamas. That's in the handout that I sent you as well. Where it has no person who has acquired information is in his capacity as a director, officer, employee, or agent of any licensee or former licensee, consul and attorney, consultant or auditor of the central bank, or as an employee or agent of such consul and attorney, consultant or auditor, consul and attorney, consultant or auditor, consul and attorney, consultant, auditor, accountant, receiver, or liquidator of any licensee or former licensee, or as an employer agent of such consul and attorney, consultant, auditor, accounting, receiver, or liquidator, auditor of any customer of any licensee or former licensee, or as an employer or agent of such auditor, the inspector under the provisions of this act, a supervisory authority, or as a director, officer, employee, or agent of a supervisory authority shall, without the express or implied consent of the customer concerned, disclose to any person any such information relating to the identity, assets, liability, transactions, or accounts of a customer of a licensee, or relating to any application by any person under the provisions of this act, as the case may be. and they give the exceptions. So you can go right there. What, we have any penalties if you breach these things? What's the penalty for breach? Hello? Hello?
Is it $25,000
Oh,
or up to 3 years, 2 years imprisonment or both?
yes, that's the penalty for breach of confidentiality. That's a statutory duty, right?
Yes, ma'am.
What about, what are the offenses under the computers? How many offenses are there under the Computer Misuse Act?
I think it's 6,
Yes, it is 6.
but I can't list them at the moment.
Okay, it's 6 offenses, and that's unauthorized access to computer material, access with intent to commit or facilitate the commission of an offense, unauthorized modification of computer material, unauthorized use of interception of computer service, unauthorized obstruction of use of computer, and unauthorized disclosure of access codes. What in these offenses, what act goes hand in hand with this Computer Misuse Act?
The Data Protection Act?
Excellent, the Data Protection Act. So we would refer to the Data Protection Act as well, because they provide protection for the privacy of personal information. Yes. And the primary objective of the Data Protection Act is to do what?
To make sure that whatever data is collected is not going to be used in an unlawful way.
Right, so it must be fair and lawful. And it's only could be used for the manner in which it was
Obtained.
collected for, that's correct. Now, what does the trustee do in balancing his duty of confidentiality? What else he has to balance?
The beneficiaries with the information that he gives out to them.
Right, so their right to information and where their right for information is covered under statutorily.
Section 83 of the Trustees
Excellent.
Act.
Yes, so you have to balance both. You have to ensure that the right to the information and your duty of confidentiality, you balance the two. And how are you protected under Section 83? What information do you give?
You can give the trustee redacted, a redacted version of the trustee and
Right,
financials.
excellent. Do I give this to all the beneficiaries? Do I have to give it to all, or I have a limited amount I can give it to?
The beneficiaries that are vested.
Excellent. What about the ones who are contingent beneficiaries and the ones who are objects of a discretionary power?
No, ma'am.
I don't have to give it to them.
No, ma'am, you're not obligated to.
Excellent. Okay, so I think we have unit 1 down. And once you all read over the handout, then we could go from there. So let's move on to unit 2. Oh, looks like we lose the rest of them.
Dominique probably got knocked out.
Okay, we have to wait 2 seconds.
Yes, ma'am.
Okay, there she goes. Okay, so in unit 2, we're gonna now identify the different types of trust documentation, understand the significance of proper documentation and record keeping, gain practical insights into the principles of trust communications, apply the legal principles from trust cases to the handling and conduct of trust communications, and obtain overall guidance on the preparation, management, and safekeeping of trust information and communications. Now, you know, from the beginning, I told you that wherever we start off is an overview, and we will now, the chapters that follow expand on what you've already summarized in the first unit, right? So I don't know if you were paying attention to that in all that you would have done in the last semester, but that's all you do. And you start off with an introduction, which is like a summary of everything that you're gonna cover. And all you do now is expand on the topic, okay?
Yes, ma'am.
Okay. So let's begin with trust instrument. Who started us? Both of you read last time?
Yes, I'll
Okay.
start.
Okay, thank you.
Trust instrument. The trust instrument is a legal document outlining the general terms of the trust, duties and powers of the trustees, trustees' obligations to the beneficiaries, and the directives regarding the disposition, administration, and management of the trust asset. Section 90 of the Trustee Act 1998 makes provisions for the trust instrument to incorporate by reference any provision set out in the first schedule to the Trustees Act, including but not limited to the powers of investment and the power to dispose of and deal with the trust fund. By incorporating the provisions within the first schedule of the Act, the terms of the trust instrument may be greatly reduced while still containing the important provisions for the proper administration and execution of the trust.
Okay, so what they've done is section 90 would cover a lot of areas that they may have omitted in their trust document. So what section 90 does is gives them a lot of powers that they may not need, but they are a catch-22. They cover them just in case they're needed. So the trust instrument is, first of all, what is the trust instrument? The trust instrument is a legal document which outlines the general terms of the trust, the duties and powers of the trustees, the trustees' obligations to the beneficiaries, and the directives regarding disposition, administration, and management of trust assets. So this is the document you have to refer to in executing your duties as trustees. So section 90 provides that you can now, you don't have to make this document so long and exhaustive. What you can do is now include section 90, which is unincorporated by reference. So what you'll do is you'll say, and we also include the first schedule of the Trustee Act, or we'll say the powers are not limited to only these, but also they include the first schedule of the Trustees Act. And so when you would have done that, you now would incorporate all of these provisions that are set out in section 90. Even if you would have already have it in your document, you may only have one reference, whereas these powers may be exhaustive. And that will include any and all that may come into being after you would have already established, once you would have already prepared your trust instrument. Because now you're guided by this trust instrument, and anything thereafter, if you didn't include it, you would have had to amend it, and then it may be too late to do it because it may look a little shady when you do it thereafter. So it's easier for you to just adopt the first schedule out of the trustee act, and that would help you to make sure that you don't leave anything out, okay? You can go ahead.
For those trusts executed after the enactment of the Trustee Act on 31st of July, 1998, the Act allows for a trust duty of $50 to be paid and affixed to the trust instrument by way of a Bahamian stamp totaling such value, and the $50 trust duty may also form the corpus of the trust. The trust instrument is deemed stamped under the Act when one of the persons executing the trust example, the trustee cancels the stamp by writing the name or initial of the trustee or person acting for the corporation, the corporate trustee, and the date of the cancellation.
Okay, so the trust, once the trust have been executed, you would affix the trust, you would affix the stamp onto the trust instrument. So it's just you buying some stamps from the post office. So before this was enacted, you would have had to take the document physically to the public treasury for them to give you, for you to pay the tax, and they affix their stamp. Now you just can now affix your stamp, purchase a stamp from the post office, and you affix it to the trust instrument, and the corporate trustee now would have their officers and directors sign. So you just need 2 persons to sign and date it, and that cancels out the stamp. And at the same time now, the document, it can be used as evidence in court proceedings. Without that stamp, you can't use the document anywhere. So if anything comes up, if you had a court matter, you couldn't go to court with this document without the stamping affixed. So that's important that you have the stamps affixed to a trust instrument in order for it to be recognized as a legal document in case of court proceedings, okay?
So you can do the stamp right before you go to court then, like literally. Because it just needs to have the stamp on it, right?
Right, but you would want to make sure the date is there, eh?
Okay.
Yeah. So you could stamp and date it. Because the date is what the date of cancellation, you want to make sure, because the court doesn't recognize a document that doesn't have the deed, does not have stamp duty on the document.
Mm.
Okay, go ahead.
One of the reasons for the fixation of the trust duty is to enable the trust instrument to be admitted as evidence in civil proceedings involving the trust, as it provides proof of payment of the trust duty. If a trust created after the 31st of July, 1998 does not have the trust duty affixed by way of the $50 stamp, a court of competent jurisdiction within the Bahamas may exercise its discretion to admit it into civil proceedings on proof of payment of the $50 trust duty and a penalty of $100 for each year from the execution of the trust.
So now you see why you don't want just put the date on it when you do it, if you're just doing it last minute, eh?
Yeah.
Because if that was created in 1998 and you now in 2021, they may ask you to pay the penalty for each year.
So how do they justify when you would have actually put the stamp on?
They can't justify it unless you bring it to their attention by not having it on there, eh? Or putting the date when you shouldn't have the date on it. So if you go and put, if your trust was established or settled in 1998 and you're now in court proceedings in 2021 and you say, oh gee, we forgot to do the stamping, but now we have to go to court, and you all have the bright idea to say, well, okay, well, let me just affix the stamp just before we get this document there, and then put 2021 on it. The court may now say you owe the government $100 for each year. So that's 21, 22, 23 years.
But what prevents them from putting the date, dating the item?
From them backdating it, who's gonna stop them from backdating it?
That's what I'm asking.
Nobody, that's what I'm saying to you. If you choose to put the current date on it, it's on you.
Oh.
Because this would not be anywhere else unless you would have provided someone with a copy of the document to show that you never had the stamp duty affixed. You see?
Yeah.
So you would want to ensure that it's so much easier just to put the $50 stamp on it, eh?
Yeah.
Yes. Because this is a private document and so it shouldn't be out there. But you know, just for all intents and purposes. Okay. Okay, let's go ahead.
The trust instrument. The trust instrument is a private and confidential document known only to the trustees, settlor, beneficiaries, and protector, if applicable, and is not required to be filed in a public registry. The act exempts the trust instruments from registration under the Registration of Records Act, in addition to all deeds of appointments pursuant to the trust deed and all other deeds executed by the trustees, settlor, beneficiaries, or protector of the trust before or after the enactment of the act.
So the trustee documents remain private. You don't have to register them in the public domain. Okay? Go ahead.
Deed of conveyance of real property or personality executed by the trustees must be registered under the Registration of Records Act in order to preserve the priority of title to the subject property of the trust. Additionally, deeds of assent in the estate of a deceased testator, which are executed by the personal representatives of the deceased testator, must be recorded in order to protect their validity under Bahamian law.
So unlike the trust documents, once you settle a trust, you know, usually all the real property and the personality, that's documents, I mean, that's personal items. So the real property is what it is, real property, property that, land. And personality is personal items, so that could be cars, jewelry, paintings, all of, shares and the like. So you need to now register them in order for me to recognize your title in law. So that's nothing that you want to keep private. That has to be registered in order for you, because if you don't register a property, so say for instance, the trustee now settles the trust, the settler settles his trust, and he had a house in Lightfoot Key. Now the trustee is now the legal owner of the trust, so they have to do a deed of conveyance where the settler transfers his ownership of the property to the trustee. The trustee now has to register that, because if he doesn't, someone else could now say that, or the settler could now transfer the property to someone else again. Say for instance, the settler was an older person and they got up in age, and one of the beneficiaries may realize, you know something, he has this house, not realizing he had a trust that he would have settled. They say, let me get this house before anybody else gets in the house. They may get their lawyers to draw up a conveyance and say, Dad, sign this for me. Dad may be senile or under undue influence because he may feel obligated to the beneficiary, and they go ahead and execute the document. And he attempts to register the document with the Registration of Records Department, which is Deeds and Documents. If the trustee has not registered his document, then there's a first in time rule recognized in law. Whoever records first is the person who has priority over the person who now tries to record thereafter, because now it'll be on you to prove otherwise. But in the meantime, if I executed a document with you from 1998, why have you not recorded that document? You now put yourself in limbo and your title in limbo, because anybody who comes thereafter would be whoever registers first. That's the person who now owns the property in law. So if you didn't do what you were supposed to do, some fraudulent act fraudulent could take place thereafter, and you would lose your title, or you would have to now go to court to try to prove you have a title. But of course, the law recognizes whoever registers first in time. Likewise, with deeds of assent, when persons would have died and you would have probated their estate, you now have to execute a deed of assent to transfer the property from that person over to yourself as the beneficiaries of the estate. If you just go ahead and do the probate and you don't transfer the property, you still don't have title to those documents until you would have executed the proper deeds to transfer on ownership is in your name. So all of these things have to be done. And it is only to protect your title to anything that the deceased person may have had, and now you're entitled to. Any questions? Okay, let's go ahead.
Trustees are no longer required to apply to the Central Bank of the Bahamas to have trusts designated as non-resident under Section 95 of the Act. Section 95 exempts any settlor, grantor, donor, or beneficiary who may be considered non-resident for exchange control purposes from exchange control approval. Trustees' duty to inform beneficiaries. Beneficiaries have a common law and statutory right to information regarding the trust in order to enforce the provisions of the trust instrument and make trustees accountable to them in the administration of the trust. Trustees have a fiduciary duty to provide information regarding the trust to the beneficiaries, which may include, but not be limited to, the trust instrument, trust accounts, deeds of appointment and retirement, and any deeds of variation relating to the trust instrument. The common law allows trustees to exercise their discretion regarding the information that they disclose to the beneficiaries, particularly those beneficiaries who have only a contingent interest.
And what we said about these said who have a contingent interest. What is a contingent interest?
They're not the
So
rightful owners, eh?
No, what it
They're
is this, they have some future interest. Contingent is it based on something happening in the
Right.
future. So they don't have any right, because this future event may never take place, eh?
Right, correct.
So you don't have to give them any information because they may never become entitled to the trust property. So now we expanding on. What are we expanding on in this trustee's duty to inform beneficiaries?
That's and under the confidentiality.
No, tell me what this section is.
83?
Yes, section
Of the trust,
83.
yeah.
So put section 83 next to this so y'all could remember.
Okay.
Okay, this way y'all would have an idea of where we going when you expanding. And what case guides you? Because this tells you you don't only have a statutory duty, which is section 83, you have a common law duty. So that means we have some case that is established common law. What is the case?
Sonia's case?
No, the turn is confidentiality. We in section
Justice
83.
Smith versus Rosewood.
Yes, excellent. So put that next there.
Which case is that?
Smith versus Rosewood.
Oh, okay.
So put that next to it, so that will give you a little tickler to remind you where we are, okay? So now you see what I say about us expanding on what we have already surmised. So now we expanding on section 83, which is the statutory duty, statutory right of the beneficiary to information, and the common law duty, which is Smith versus Rosewood, tells us they have a common law right of information. Okay, let's go ahead.
As previously stated, beneficiaries are not entitled to trust information relating to the trustee's exercise of discretion regarding deliberations and or distributions and trustee correspondences to each other and to other beneficiaries. However, the trustee's duty to disclose information and the beneficiary's right to trust information are the subject of the recent decision in the case of Smith versus Rosewood Trust Limited, Schmidt. In Schmidt case, the court held that the beneficiary's right to information was not only reliant upon the trustee's fiduciary duty to keep them informed regarding the provisions and administration of the trust generally, but also upon the court's inherent jurisdiction to ensure that the trust is administered in accordance with the terms of the trust, and if necessary, act on behalf of the beneficiaries to achieve this objective. Therefore, the classification of a document as a trust document, the beneficiaries' interest and their ownership rights to trust assets were not the primary consideration in determining the beneficiary's right to information. Based on the Smith's decision, a document will be ordered to be disclosed if it would be conducive to the proper administration of the trust. It does not matter whether the document is classified as a trust document. Requests from beneficiaries must be reviewed on a case-by-case basis, and trustees should be guided by the purpose for the beneficiary's request and the interest of the beneficiary. Ms. Dawson?
Sorry, I fell out for a minute, so hello, you can hear me?
Yes.
Okay. I lose you at based on the Smith decision.
Sorry, I
She
didn't hear
finished
you.
that particular paragraph, Ms. Dawson. She stopped at request and interest of the beneficiary.
Okay. So based on the Smith decision, where are you? Okay, good. So based on the Smith decision, a document be ordered if it was conducive and proper.
So continue.
So based on this decision, they said a document will be ordered to be disclosed if it would be conducive to the proper administration of the trust. So what does that mean? It doesn't, it's not up to the beneficiaries to tell me I have to disclose it. The court will have to give me guidance or direction if whether this document is to be disclosed to the beneficiary, especially if it's classified as a trust document, which means that it's something that should not be open for all beneficiaries to see. So what we call as a trust document. What we call in a trust document.
Like the minutes?
Because we have it in here, they have the trust document, so they have what the trust documents are.
The deeds and stuff like that?
So we have the trust document, which are the classification of a document as a trust document. The beneficiary's interests and their ownership rights to the trust are, but not the primary considerations in determining the beneficiary's right to information. So the trust documents, what we said, the trust documents were earlier.
I remember we spoke about the trust instrument. But I
Yeah,
don't know
what, no, just look right in the second paragraph.
Right, I was saying it's like the accounts, the deed of appointments and retirement,
Right.
the deed of variation relating to the trust
So they have a
instrument.
right to information which may include but not be limited to these documents. But what are we say, what is the court, what is the court saying? Because it's still up to the trustee to give this information. If, suppose the trustee don't feel they should have this information, what happens? How is the trustee guided when you're asking for information?
by the purpose of the beneficiary's request and interest.
Yes, so when you ask for information, I'm guided by the purpose for which you're looking for this information and your interest in this trust as a beneficiary. So you may have a contingent interest. So I'm looking at it on a case-by-case basis. And I may say, no, I don't think you need to have that information. So the Smith case says what will happen in some instance. The court may order it to be disclosed.
Yes, if it may be conducive to the proper
To the proper
administration of the trust.
administration of the trust. So only in instances where it is important for us to continue with the proper administration of this trust, we may allow you to disclose information to these beneficiaries, but it will be the court to make that decision. The trustees will not try to do it on their own, more or less. They will seek the court's guidance because they rather that to be covered than the beneficiaries being able to come back after them to say you would have disclosed information you should not have to another beneficiary, you see? So they would now approach the court instead of them leaving it to themselves to find out. So they may get a legal opinion and the lawyer may say, you know something, you better seek the court's guidance. And so in that case, that's where they will now seek the court to tell them, to advise them or to say, yes, you may disclose this information. And they would cover themselves from any breach that another beneficiary may now try to sue them for breach of trust, okay? Any questions? Okay, let's go ahead. When you finish with this one, internal trustee communication, then Sanika will start with us. Thanks.
Following the following the decision in the Schmidt case, a trustee should take into consideration the following information when making a decision to disclose trust information to beneficiaries: the nature of the request, the reasons for the request, the information being requested, and the sensitive nature of the information being requested. Additionally, the trustee may refuse to accede to a beneficiary's request for information if there are legal grounds to do so. Information is privileged. The information is confidential as per one beneficiary to another beneficiary. The information in the trust is a remote or contingent one. The information may be prejudicial or adverse to the trust. Example, challenge to the validity of the trust. And the disclosure of the
Sorry, which
information
page we on?
may be too
Why
costly.
the electricity bill come back up?
Page
We are
26.
on page 26.
Okay, thank you.
Mhm.
Arguably, the decision in the Schmidt clarifies and reinforces the provision of Section 83 of the Trustee Act of 1998, which gives beneficiaries of Bahamian Trust the right to information under certain specified conditions and in certain specified circumstances. Example, trust accounts, trust deeds, as applicable and redacted. Under Section 83, trustees must make all reasonable efforts to inform beneficiaries who have a vested interest in the trust of the existence and the nature of their interest in the trust. Notwithstanding the conditions outlined in the Smith and Section 83 of the Act, trustees should be guided by the fact that they can still consider whether to disclose only part of the information requested, example, redacted information, or accept an undertaking in relation to the use of the information disclosed before exercising their discretion not to disclose or accede to a beneficiary's request for information.
So they still, what they say? They are guided by the purpose for the beneficiary's request and the interest of the beneficiary. So now it just reinforces the provisions of Section 83. They have a right to information under certain specified conditions and certain specified circumstances. So those conditions and circumstances may be the trust deed or the trust accounts. However, the trustee must inform, they have a duty to make all efforts to inform beneficiaries who have a vested interest in the trust of the existence and the nature of their interest in the trust. They can consider whether or not they're going to disclose only part of the information requested, example, the redacted, or accept an undertaking in relation to use the information disclosed before exercising their discretion. So they may ask the beneficiary, give me an undertaking that this information that you're using is only for this purpose, and this won't come back to haunt me when I give this to you. So based on the beneficiary's undertaking, they may sue the beneficiary on their undertaking as well if they use it for any other purpose. So before they just say no, they may go a step further to say, well, you may need this for a worthwhile purpose or it's important, so I will try to help you out, but I need you to ensure that you're going to use this for the purpose that you told me you were going to do it. And so give me an undertaking that that's the only reason you want this information. Okay? Any questions on Section 83 on the Smith and Borswood case, which is the right of information? Duty, the trustee have to inform the beneficiaries of their rights and interests in the trust as soon as possible, and only the vested ones. Anything? Any questions? Okay, let's go to internal trustee communications, and so Sanika will start.
Internal
Thank
trustee
you,
communication.
Dominique.
Trustee communications are important in the administration of any trust. Such communications must be written carefully by the trustees and accessed tightly controlled. The communication should be consistent with the provisions of the trust instrument and in compliance with the law. They should cast no aspirations on the reputation of the trustee, nor reflect a dereliction of his duties in the administration of the trust. The trust instrument is the primary source of the exercise of the trustee's duties and powers, and compliance with the terms of the trust is fundamental to the discharge of the trustee's obligations to the beneficiaries. The trust instrument is legally binding on the trustees, unlike the settlor's letter of wishes and memorandum of wishes, which provides only guidance to the trustees and is not legally binding and not intended to create a separate trust.
So the trust instrument is the primary source for the trustee to exercise its duties, powers, and comply with the terms of the trust. That's where you find all of your information, the trust instrument. It is legally binding on the trustee. However, the settler may usually present a letter of wishes or a memorandum of wishes. That does not bind the settler. The only document that binds the settler is the trust instrument. The letter of wishes may be more or less a guide or an introduction more about who the beneficiaries are, especially in the case of a discretionary power. So you would say, you know, my son or daughter, she likes to spend money unnecessarily, or so when you think about these things, so I want my son to go to college and But this is only a guide. This doesn't hold the trustee to any legal obligations. They only use this to know more about the beneficiaries and to exercise their powers, their discretionary powers. So it's not a legally binding document. The only document that legally binds the trustee is the trust instrument. Go ahead.
The settler's letter of wishes, which is normally used in discretionary trusts, as the trustees will have very little information concerning the circumstances and requirements of discretionary beneficiaries, is not fixed trust and not fixed trust often stipulates specific personal information regarding the beneficiaries, example, ages, residence, special needs and circumstances, relationship to the settler, etc. And more importantly, the settler's wishes regarding how we would like the trust administered and who we would like to benefit from the trust. The information is particularly useful to the trustee who may be unfamiliar with the circumstances or personal details of the beneficiaries in operating the offshore trust and may need more guidance in discharging the terms of the trust by consideration of the non-legally binding letter of wishes. The information should be clear and comprehensive as it is meant to represent the explicit wishes of the settler in the administration of the trust and the distribution of the trust assets. The effect of the letter of wishes is that the terms need to be followed by the trustee. The trustee and settler's advisors do not have to follow the information in the letter of wishes and therefore can choose to take an action or reach a decision which is not covered by or perhaps contrary to a wish that is expressed in the letter. The letter of wishes is not required to be signed by the settler of the trust, even though it outlines his wishes. And in the instance of the memorandum of wishes, a settler may elect to have the same prepared by the trust officer, a relative, or his attorney.
So we realize now that this letter of wishes has no binding effect. You clearly see that it's just a letter with more or less just my wishes, what I would like to happen, but it doesn't in any way bind the trustee to do those things, right? You've seen a letter of wishes before?
I have.
Yeah, so it's nothing binding. It just gives you a guide. So usually the trustee looks at it to help them in administering the trust, but they don't have to follow it to the letter, okay? Okay, go ahead.
It may provide detailed guidance on the settler's desires with regard to management, investment, and distribution of trust property, as well as its considerations for the special needs and requirements of specific beneficiaries. Trustees are not required to disclose the letter of wishes to the beneficiaries and are protected by the provisions of the Trustee Act 1998, which prohibit such disclosure. Additionally, in the common law case of Australian Hartigan Nominees Pty Limited v. Ridge, the court dealt with the rights of a beneficiary to receive a copy of the letter of wishes, in which it was held that the letter of wishes will not be disclosed to beneficiaries on the basis that it was a confidential letter between the trust and settler. It is important that the trust is not administered purely in accordance with the terms of the letter of wishes. If the trustees follow the letter of wishes blindly, the trust might be declared as invalid and the arrangement may be treated as a sham, as it may appear that the trustees never intended to exercise any of their powers independently, and similarly that the settler never intended the trustees to exercise the powers given to them under the terms of the trust. The memorandum of wishes is alternatively used instead of the letter of wishes. In this instance, the settler's wishes are recorded in a file note, which is placed in the trust records. A copy is sent to the settler for his review, but is not signed. The note is becoming more popular as it is an internal correspondence of the trustees and not correspondence from the settler.
So unlike the letter of wishes, the memorandum of wishes is done by the trustees. So it's more or less a memo to the file, based on the information that the trustee would have received in the initial interview with the settler. So thereafter, they able to use this information to guide them in making decisions. Again, this is not binding on them, it's only a guide. So the letter of wishes is usually done by who?
The settler,
And the memo is done by the,
trustees.
excellent. Okay, go ahead.
The trust instrument should be clear and conclusive regarding the advice to be obtained by the trustee and the circumstances in which the trustee should seek such advice from agents appointed and supervised by the trustee, example, attorneys, investment advisors, etc. In certain instances, trustees may be required to obtain consent and/or directions from the settler only if he retains the power to direct the trustees in the trust instrument, protector, the court, or another relevant party as dictated by the terms of the trust instrument.
So
Trustees,
you see in the trust instrument, you see, we go back to the trust instrument. So before advice could be obtained by the trustee, he has to ensure that the trust instrument gives him this authority to obtain advice. Where he could seek advice from agents appointed unsupervised by the trustee, attorneys, investment advisor. So this should be a part of the powers he has to use within the trust instrument, because he could not seek advice if he doesn't have that power to seek it. He may have to go through a protector or seek the directions from the settler as to whether he can go and obtain advice on any information regarding the trust. So this is important to make sure that these provisions are set out in your trust instrument. Okay? Go ahead.
trustees in many instances through trust committees often deliberate amongst themselves when they receive a request for distributions from the beneficiaries. As a matter of standard practice, these deliberations are documented in trustee minutes. These trustee minutes are one of the documents that are prohibited from disclosure to the beneficiaries and are privileged under Section 83 of the Trustee Act 1998. This statutory prohibition is required to protect the trustees from potential liability or suit from the beneficiaries and allows trustees the freedom to discuss their reasons for their decision without the fear of legal repercussion. The trustees' minutes often detail the information that the trustees considered in making their decisions, their rationale in deciding, how they voted, and the concerns that may have been raised during their discussions. Some trust practitioners hold the view that the details of trustee deliberations should be as brief and concise as possible, revealing very little of the trustees' reasons for fear of possible disclosure and potential incrimination, if required to be disclosed for any reason. Other practitioners hold the view that fairly detailed documentation of deliberation provides necessary, clear guidance to trustees for future considerations or deliberations in the administration of the trust when faced with similar requests or circumstances.
So in certain instances, some trust practitioners believe you should be concise and to the point. So you don't leave yourself open to any, I guess, repercussions that may occur if these documents are now considered what? What would we say earlier that the court may now say what?
They may say that the beneficiaries, under special circumstances, may be able to view those documents.
Excellent. So it'll be ordered to be disclosed if it's conducive to the proper administration of the trust. So in order for us to not be open to scrutiny or to say we would have acted outside of our powers, let's stick to the matter at hand and answer concisely and clearly what we made the decision and go from there. But when you tend to put too much information in, then it now comes back to haunt you. Again, in another instance, they're looking at it to say, I want to make sure I'm covered to show how I came up with this decision, what considerations, what I did in coming to this decision. And that may help them as well in a court proceeding, or it may hurt them. But some feel they need to put more information in, and some feel the less information better. So as much as these are not for the eyes, these are supposed to be what we say about these? These are considered,
Private.
so they're privileged, right? So since they're considered privileged, they should not be disclosed, but the court may order it may be conducive to the proper administration of the trust. So if they are now disclosed, you should be able not to be open to scrutiny. Okay? Okay, go ahead.
As part of their deliberations and in preparation of their minutes to reflect such deliberations, trustees often review the letter of request from the beneficiary, the trust statements of account, any correspondence from the protector, if applicable, and any other document that may be necessary in accordance with the terms of the trust to review. It is important that the deliberations by trustees and/or their decisions are not disclosed to beneficiaries for the reason or reasons mentioned previously. Additionally, trustees and trust administrators should take extra care to ensure that trustee minutes are filed properly and securely and separate from other trust documents due to their confidential and sensitive nature.
Okay,
External-
so even in your filing, you should ensure that you keep these documents separate from the documents that they actually have the right of information to, right? So that means your correspondence, your minutes, and all the other documents that are not for the beneficiary should be kept in a separate file from the trust accounts and the trustee, right?
Yes, ma'am.
Okay. All right, so we'll let, who didn't read it? Chrisia, you didn't read it. Chrisia read? Not yet.
No, ma'am.
Okay, you could take us home with external communications.
Trustees should be very clear and direct in their correspondence with external parties, particularly those agents to whom they delegate certain duties in accordance with the trust instrument. The trustees should make it plainly clear that they act as a legal owner of the trust property and discharge their duties and obligations in relation to agents, external parties as prescribed by law and the trust instrument. As a matter of good practice and to ensure clarity in their instructions or requests, trustees are encouraged to cite the relevant provisions of the trust instrument and or the trustee acts, other trust legislation that authorize and allows them to appoint agents and seek their advice, assistance, and or directions, and to enable them make the specific requests or statements with regards to external communications. Additionally, the trustees must properly record their correspondence and create a clear audit trail with regard to trust communication to external parties. This practice allows the trustees to, satisfactorily supervise their agents and make them accountable as and where necessary in the proper administration of the trust. A trustee's duties and obligations to act in the best interest of the beneficiaries of the trust generally should be forefront of the trustees' minds, should be at forefront of the trustees' mind when communicating internally and externally. Trustee communications to beneficiary is also important as they represent the tone and authority of the trustees in discharging their duties and responsibilities and properly handling the requests and concerns of the beneficiaries. Any response or communication to the beneficiaries should be done in accordance with the terms of the trust instrument. Trustees should be guided by professional communication protocol in answering beneficiaries' requests in a timely and responsive manner, and may at times find it necessary to seek advice or guidance by external legal counsel if the request involves a complex legal issue or a detailed response.
So what the trustees in their communications must do is to ensure that when they're responding, it is in concert with your trust instrument. So when they have requests, they will refer to the trust document or the instrument when they are answering the request. So in accordance with the provisions of the trust instrument, you have requested a distribution, and accordingly, and as guided by whatever sections of our trust instrument, we are able to produce, or we are providing this distribution to you after deliberations or whatever. You make sure that you are not speaking as if you're doing it on your own, but you're doing it under the guidance of the trust instrument. Likewise, when you are communicating with external parties, you would now also refer to the powers by which you have the authority to now instruct them or ask them to do certain things. So they know that you're guided by a document, and accordingly, you want them to respond in the manner. So you're showing them that you're not acting on your own, but you are guided by the proper, I guess you'd say, you have a document that is actually instructing you on how you are to go about your duties. So it's your the instrument, the trust instrument. So it's only in order for you to keep your communication professional at all times, so that you don't open yourself to scrutiny, and so you can show that you are always representing the trust company as guided by the trust instrument. Okay.
That's
When
all.
you seeking legal advice, likewise, you would refer to the document that you're asking them on advice about, and how you are able to ask them for advice. You'll say, according to the trust instrument, the trustee has the power to seek legal advice under the provisions of section whatever. And in this instance, we are now requesting your assistance in providing us advice on whatever matter you're now asking them for advice on. Okay?
That's all.
Go ahead.
Okay. Oftentimes, beneficiaries may not be aware of or familiar with the legal duties and obligations of trustees, and it is the responsibility of the trustee to ensure that such duties are properly communicated to beneficiaries to protect the fiduciary duty of the trustee and the overall interest of the trust. When trustees are communicating their decisions regarding the distribution to beneficiaries, such communication should be clear and direct. Trustees are not required to and ought not to disclose the reason for their decisions or the details of their deliberations in order to avoid potential liabilities from possible claims, actions, or lawsuits from beneficiaries who may feel that they are being treated unfairly.
So in this instance, just get to the point. You're making the distribution clear and direct. You don't need to go into reasons or anything else, so you don't open yourself up to unnecessary lawsuits. Okay? Any question on external communication?
So you mean like, say you're about to give out money to beneficiaries.
Mm-hmm.
If I give one person $1,000, the next person five, I don't have to give them an explanation of why I give that to them like that.
No, so you, first of all, they ask for a distribution, or you just giving it based on the trust, how the trust is set up?
They ask.
Okay, so based on their request, then you respond to them accordingly. So say for instance, so you're saying in this instance, both of them asked for $1,000.
But I gave one more than the other.
Okay, so when you don't have to disclose the reason for your decision, right?
No.
So The only way they're gonna now find that out, because you may want to just to avoid unnecessary problems. But if you don't, what they now will do, seek what? Seek the court's help, eh?
They'll seek
So
the
you
court's
have to
help.
make sure that why you made the decision, because you don't have to give them the reason. But if you want to just avoid unnecessary long drawn out battle, you could say, you could explain to them at this time, based on your request, I don't think it's necessary for you or whatever. Or you need to, they may ask them for more evidence. So they may put them to a higher task to provide evidence as to why they need certain monies. And if they can't justify it, then I could very well say, well, no, I don't think at this time I'm able to provide you with that. But however, I can give you 500.
Yeah,
You see, but you
okay.
just have to make sure that you are covered in making your decision. So your decisions have to be sound and based on what you know and whatever they requested. So you have to take into account, remember, it is on a case-by-case basis. It's not a general stick that you, or general brush you wipe everyone with. So everything is on a case-by-case basis, and you make your deliberations on each and every beneficiary.
Mhm.
So you don't have to give the reasons. However, you may want to give an overview, not detailed reasons, because you don't want to open yourself up to too much scrutiny. However, you could, and thereafter, even if they go to court, you should be able to show that you would have made the decision based on sound principles why you would not have done what you did. Okay,
Yes, ma'am.
any other questions? Okay, let's go to the questions then. Number one, the blank is a legal document outlining the general terms of the trust, duties, and powers of the trustees' obligations to the beneficiaries and the directors regarding the disposition, administration, and management of the trust assets. Where we'll find that.
Page 24, first paragraph.
Excellent, and what that is?
The trust instrument.
Okay, trust instrument. Number two, blank of the Trustee Act 1998 make provisions for the trust instrument to incorporate by reference any provision set out in the first schedule to the Trustee Act 1998.
Section 90. That's page
Section,
24, the second paragraph.
okay. Number three, the trust instrument is stamped under the act when blank. Where we'd find that answer?
24, third paragraph.
And what that is?
When one of the persons executing the trust cancels the stamp by writing the name of initials of the trustee or person acting for the corporate trustee and the date of the cancellation.
Okay. Number four, the act exempts the trust instrument from registration under blank in addition to all deeds of appointment pursuant to the trust deed and all other deeds executed by the trustees, settler, beneficiaries, or protector of a trust before or after the enactment of the act. Where we find that?
Yeah, with interest.
So page 25, subparagraph.
Say it again.
Page 25, first paragraph.
And what is
Yeah.
that?
Trust instrument from registration under the Registration of Records Act, in addition to all deeds and appointments pursuant to the trust. All other deeds
So it
executed
is
by the.
what it is, the trust instrument. Right? Hello?
Yes.
Yes, trust instrument. Number five, beneficiaries have a blank regarding the trust in order to enforce the provisions of the trust instrument and make trustees accountable to them in the administration of the trust. Where we'll find that answer.
Page 25, fourth paragraph.
What it says.
Beneficiaries have a common law and statutory right to information.
Okay. Everyone get that, eh?
Can you repeat that, please?
That's number 4.
Number 5.
Number 5, but it's on page 25. Under trustees' duty to inform beneficiaries.
Okay. A common law and statutory right?
Yes. Okay, number 6, trustees have a blank to provide information regarding the trust to the beneficiaries, which may include but not be limited to the trust instrument, trust accounts, deed of appointment, and retirements, and any deeds of variation relating to the trust instrument.
I would say fiduciary duty.
Will you find that?
That's page 25. Of the 5th paragraph.
Has everyone got that?
Yes, ma'am.
Okay. However, number 7, however, the trustee's duty to disclose information and the beneficiary's right to trust information are the subject of the recent decision in the case of blank. Where we'll find that?
Page 25. Smith versus Rosewood.
All right. Number 8, the settler's blank, which is normally used in the discretionary trust and not fixed trust, often stipulates specific personal information regarding the beneficiaries. Example, ages, residence, special needs and circumstances, relationship to the settler, etc. Where we'll find that answer. And the settler's what?
Letter of wishes.
Where we'll find that answer.
Page 27, second paragraph.
Okay. Letter of wishes, okay? Number 9, trustees should be very blank in their correspondences with external parties, particularly those agents to whom they delegate certain duties in accordance with the trust instrument. Where we'll find that.
That's page 29. They should be very clear and direct.
Okay. Hold on one sec. Okay, so this unit, we should have been able to identify the different types of trust documentation. Give me 3 examples of trust documentation.
The trustee instrument, trust instrument.
What is that? That's a what? Is that a legal document?
Yeah.
And what is it?
It basically outlines the general terms of the trust, the duties, the powers of the trustees, the obligations to the beneficiaries, and the directives regarding the disposition, administration, and management of the trust asset. So basically, it's almost like the memorandum or article of association for how the trust should be governed.
Yes, excellent.
That's what I understand it to be.
So the trustee is guided by this document then?
To a degree.
Yeah, this the document he has to be guided by. So this the legal document. This is where he has to go for all information on the trust. Okay?
Mm-hmm. Okay.
What else we have under the, what other document we have?
This letter of wishes.
Mm-hmm. Another one?
The memorandum of wishes.
Yes, okay. Any other ones?
There are resolutions. Hello?
I'm here. Hello.
Ms. Dorset?
I think something happened to the computer.
Oh, okay.
Hello?
Hey, Ms. Blossom.
Okay, so we also have the trustee minutes and the accounts as well, eh?
Mm-hmm.
What is the significance of us keeping proper documents and record keeping?
Because it's very necessary. It should be held separate and apart from any of the actual business files, because each trust has their own files. It should be kept confidential and ease of reference.
Right,
Such
now
as the
when we
minutes.
keeping, okay, go ahead, you go ahead
I was
to
gonna say,
it, go
such as
ahead.
the minutes and the other documentation that is the trust is governed by, such as the trustee instrument. That shouldn't just be thrown in one file anywhere. That needs to be easily found and well documented.
Right, so what's the significance of us keeping, say, the trust instrument and the trust account separate from the trustee minutes, the correspondence and all those things?
I'm not too clear on that.
Anybody remember?
The trustee minutes and correspondence should be kept separate because those are documents that are private, that the beneficiaries or the public should not be able to see, because those are deliberations of distributions and so forth that were made by the trustees using their discretion.
Right, so what about the trust instrument and the accounts? They could see them, eh?
You mean the beneficiaries?
Yes,
The beneficiaries can see the trust instrument, but a redacted version of it. And they can't see the trust.
Right.
But they have to be
so
vested.
that's the reason why we keeping them separate then.
Yes, ma'am, because there's certain documents they can see versions of, and there's certain documents that they cannot see at all unless the courts deem it fit for them to see it under special circumstances.
Excellent, so we keeping them separate just as a guide for us. Because
Yes,
some of
ma'am.
our documents are privileged to us only, and some are for the beneficiaries. Which beneficiaries we giving these to?
The vested
We
beneficiaries.
giving these to the one, yeah.
Yes, vested, excellent. What about communication? When we talking to external parties or beneficiaries, how should we be guided?
Just by what the trust instrument said.
Yes, so what the trust instrument tell me, how I should talk to them?
You should keep confidential what's confidential and give them what they could get.
So my communication should be
Clear, concise, and direct.
excellent. That's what we need to hear. When you answering your question, eh? That's what you have to make sure, put those words in there. When you when you communicating with these people. What about the legal principles from trust cases to handling and conduct of trust communication? What legal principle we have for cases? We have any legal principles or cases that guides us?
Excuse me. I guess we have a few.
Tell me what that case is.
Australian Hartigan nominees versus Rich. Where the court dealt with the rights of a beneficiary to receive a copy of the letter of wishes, in which it was held that the letter of wishes will not be disclosed to the beneficiaries on the basis that it was a confidential letter between trust and settler.
So confidential documents the court will adhere to and say that's not for the beneficiaries to see, eh? So some things are not for the beneficiaries to see. That's only between the trustee and the settler. The letter of wishes, what they say about the letter of wishes and the trustee following the letter of wishes. What happens if he follows it blindly? Meaning he just does everything what it says.
Then it would make the trustee as though it's a sham
Excellent. Yes.
because
Excellent.
it would seem as though the settler is running the trust and not the trustee.
Excellent.
Mhm.
So when we preparing, managing and safekeeping the trust information and communications, we are guided and how we should do, how should we keep these documents? And keeping the documents of the trust, we are guided how we should keep them,
In a safe place.
right? And we should have them separated.
What is yes for those who have a vested interest and those who do not.
And then two, we have certain documents that they have a right to and some they don't. Also, we should have proper record keeping of our deliberations, eh?
Yes.
And they are kept as what?
Where they going? They kept it confidential.
No, what we call them? What we call our deliberations?
Minutes and resolutions.
Excellent. Minutes and resolutions. So we should have a file for that.
Where they going?
And then we have directions and correspondence that when we communicate with external parties, and when we're looking to know whether we can speak with external parties, what we have to look to first.
The trust instrument.
Awesome. Okay, look like you all have this chapter down pack. Just look like an easy chapter for y'all. So we have Smith and Rosewood and Australian Hartigan versus Ridge. That's the cases that came out of this one. Any questions on this chapter? No?
This chapter seemed pretty straightforward.
Yeah, this one was easy. Remember what section 90 of the Trustee Act tells us?
That the first schedule from the trust instrument could be set out.
So what we could do, incorporate what? The trust instrument can incorporate the first schedule of the Trustee Act.
Of the Trustee Act,
Right.
1998.
And that allows us to put in there what? What the first schedule deals with. You all remember?
The terms of the trust instrument?
No, what it deals with. Powers, eh?
Powers, yes, ma'am, powers of investment.
Right.
Dispose and deal with trust funds.
Right. Y'all remember what the trustee duty is? What's the stamp duty for the trust?
$50.
Excellent. Okay, so y'all could read over the handout that I sent. Attorney and provincial. And read a little bit more on duty of confidentiality. And I think unit 2 was fairly easy for you guys, eh?
That's fine.
Okay, so we have unit 3, which is a short and direct one as well. We don't have much to do with these, so we could just make sure we read the cases, eh? So I'll try to send you some cases ahead. Phil and Dalton especially, okay? Okay?
Yes, ma'am, yes, ma'am.
All right then. If you have no further questions. No?
No, ma'am.
Okay. Enjoy the rest of your weekend and I'll talk to you again on Thursday, God's willing.
Yes,
Okay,
ma'am.
thank you. You
Take
too.
care.
Thank you.
Okay.
All right.